Good morning, everybody, and you're most welcome to Southeast BIC's 8th webinar since this crisis began. It's hard to believe we're in month 8. A couple of things to note. We are recording this webinar for use on our YouTube and social channels afterwards, so please be aware of that. And there is a Q&A box available during the webinar that you're more than welcome to ask questions as you think of them, and we'll put them to our panel as we go along. But a word of warning, if there's any sensitive information, please don't put that in the Q&A information. That would need to be handled on a one-to-one basis. So any sensitive intellectual property information I'm talking about, you'd need to keep that till a one-to-one opportunity. So I'm Rosemary Ward. I'm a consultant here at Southeast BIC, and today we're delighted to be joined by our friends at FR Kelly European Patent and Trademark Attorneys, and by Joe Doyle from Enterprise Ireland. So we work with startups and scale-ups every day, preparing them for investment. And one of the key questions every investor asks is, what is the innovation here? What's defensible? And the answer to this is what we're talking about today, and how it impacts on your customers, suppliers, competitors, and potentially your exit. So very quickly, I'm going to remind you of what we do. You can see the agenda there. And I'll go through that in a little moment and explain who everybody is. But I'll quickly remind you about what we do here at Southeast BIC first. We work with startups and scale-ups every day, preparing them for investment. We work with ambitious, innovative startups in the Southeast and offer services around project evaluation, investor readiness, investment, and incubation. We also manage the Halo Business Angel Network here in the Southeast, which matches private investors with those innovative startups seeking investment. So this morning, we are joined by a great lineup of speakers. The team at FR Kelly are very clear about how creative output is linked to business success. They work with startups and SMEs right up to corporates and academic and research institutions. They have teams in Dublin, Cork, and Belfast and offer a client-based tailored service. Today, they're offering a one-to-one meeting opportunity to anyone who has attended this webinar, which is a fantastic opportunity that we know will be very popular with you guys. We will send you out details of this offer after today's webinar. Joe Doyle is Enterprise Ireland's IP manager and is a technologist and IP specialist who is committed to raising awareness of the essential role IP plays in innovation and enterprise development. Today, he will outline Enterprise Ireland's supports around IP for Irish startups and SMEs. So without further ado, we will kick off now with Paul Keane, who will talk about patents. Paul is a European patent attorney and an Irish patent agent and a partner in FR Kelly with over 15 years experience. Paul, I'm going to ask you to share your screen now, if you could, and take yourself off mute.
Yeah, good morning. Good morning, everybody. So yes, I'm a European patent attorney. Yes, and I'm a partner with FR Kelly. My background is in electronics. I actually have an electronic engineering degree with University of Limerick, and I have also a higher diploma in microelectronics from UCC. So the typical type of patents and intellectual property I deal with is related to software and electronics. However, we have other teams of people in FR Kelly to deal with life sciences and mechanical and the various other technical areas. So this morning, I'm challenged to give a discussion on patents in 10 minutes. So what I'll try to do is give a brief overview of the requirements of patents and then maybe reasons why you would file patents. But again, I want to reiterate, any confidential information, any trade secrets should be disclosed publicly, and it should be just done by one-to-one, and that's very important. So patents, so effectively what patents do, they actually protect the innovation, all right? They protect how something actually works, the technical functionality, the fundamental principle of how your invention, your process, your device operates, all right? It doesn't protect how something looks. That's a different form of technology, the protection called design, but this covers about the technical, how something operates. So in patents, we always we'll always refer to the prior art, and what we mean by prior art is like existing publications, like university papers, maybe other published patents, and we look to see if how do you differentiate from what already is out there, and what we call previous publications as prior art. Okay, but there's often overlap in a patent document between prior art and invention, and what we're looking to do in the patent is to look at what is your unique selling point and try to protect that. That is your fundamental principle. So these are the criteria. So we're always looking at how you separate yourself from the prior art. What is your unique selling point? Okay. So the basic criteria for patents is that your invention must have novelty. So that's very easy to achieve. All you need to have one aspect, one feature, one step in your process that's new. It's very easy to achieve. The second criteria is more difficult in that new aspect has to be inventive. So what we mean by that is that it has to have a technical advantage. Okay. And the final criteria is the industrial applicability. But in reality, everything is industrially applicable. So there really is only two criteria: novelty and step. And the step, all we're looking at is, are you providing supplier advantage? Okay. So we look at what can be patented. In most jurisdictions, there's no definition of what a patent is or what invention is. So it's quite general. It can be applied to most technologies, most forms of what companies are doing. So there's no definition. But there is the basic criteria through case law is that it has to solve what you're doing must provide a technical solution. It has to provide a technical solution. It has to solve a technical problem. So your invention must provide a solution to that technical problem. So, that is very, very general. If you're providing some advantage, if you're improving your process by a few percent, if you enhance security, using better memory, or you're creating a mobile phone that works in a better way, you're providing a technical solution. So there's often an understanding that, say, software, it isn't patentable. So I'm trying to give a few examples of what technical, because it can be, technology can be quite diverse, So what do we consider to be technical? There's a misconception that the software isn't patentable. The reality is, I would say I would spend 85% of my day working on software patents, if not more. A lot of the largest patent filers are software-related companies. So software is patent provided it has a technical provides a technical solution. For example, in image processing, in the photograph, if you're like the squirrel on my slide there has red eye. If you come up with a process to remove red eye in a more efficient way, maybe reduce processing power, or do it in a more faster fashion, then that you identify the problem, you identify the solution, and it is technical. So software is technical when you can tie it to a technical solution. But what isn't patentable would be, for example, a mere automation of administration process. For example, keeping track of HR data. There really is nothing. There's no technical problem maintaining records. There's no technical solution by automating a process that could be done manually. So that's important, So what you're always looking for, say, making a decision is something. Is it? Can what I'm doing be tied to addressing a technical problem? But it's imperative that you do not disclose or sell any product. Or disclose any marketing material, whether it's via LinkedIn or on your own website or YouTube, before you actually file your application. It's important because once you put in the public domain, it's no longer possible to be novel. And that's very important. That's where a lot of startup companies fall down, is that they're too eager to get market advantage by telling all their trade secrets on their website, and yet they're destroying their own novelty. They're destroying their own ability to get the patent. We go back to what is the basic criteria: novelty and inventive step. If you disclose before you file, you can't make the first basic criteria, novelty.
Paul, sorry, Paul. Could you get in a little bit closer to your microphone? We're having a little bit of sound difficulty. There's a bit of coming in and out. Sorry now to interrupt you.
No worries. Well, yeah, so maybe I just repeat, it's important, the two basic criteria is that you need novelty and inventive step. Novelty, you need one new feature, and inventive step, you need to have a technical advantage over what's already out there. But what's imperative is that you do not disclose your invention before you file your application, because then that would destroy your novelty. I hope, Rosemary, that's clear enough.
It's just a little bit fuzzy, Paul. We're not getting a brilliant sound from your end, unfortunately. But keep up close to the camera and to the mic.
Okay. Well, regarding inventive step, the criteria for inventive step is that a person skilled in the art looks at what you're doing and what's already out there and makes a determination, would it be obvious? So today is, I guess, a gloomy day in Ireland in that we're on our second lockdown. So today I thought I'd put a bright slide up showing all the great innovation and great Irish companies out there. FR Kelly's been around since 1927 protecting Irish innovation. But by just going through a sample of these companies, it gives an example of the type of technical technology that could be patentable. That company, looks at using machine learning and IoT for protecting bees. You have Blue Drop Medical, which uses sensors for detecting diabetic foot. You have Irish Sea Contractors like Down and Gorey, which is a world-leading subsea cabling company. To Ace Tech, which uses vehicle intelligence for emergency vehicles. To Soapbox, to voice recognition. And then you have a host of other companies, bigger name companies such as Kerry and Combilit. But all these companies, they all started on a journey, an IP journey. They all started from a small startup. They all started from a single piece of IP, okay? And it's important that you have a plan for patents in your business plan to allow you to progress in that journey. So I suppose in order to take that journey, you need to file your first patent application. You need to get that patent pending status. Once you file a patent application, you automatically have a patent pending status. And you have taken that first step in that journey for maybe where Apis Protect are, a small startup, to where maybe Kerry, a world-leading food ingredients company that is multinational. But each of them took that first step. And that's what we're trying to encourage people. Take that first step and make sure you examine that the patents are part of your business plan. Here, just looking at some of the reasons why you would file patents. Patents, they add value to your balance sheet. They add value to your company. So when you're exiting or when there's a sale taking place, the value of your company significantly is increased based on the number of your patents. Often, before a merger happens, people will do due diligence on the number of patent applications, the number of patents you have. It's important that you have a number of patents protecting your innovation to ensure that you're maximizing your value. It also allows you to help secure investment along the way. Nobody is going to invest in ideas that aren't protectable, because what's to stop somebody else taking those ideas and running with it? So investors want to ensure that your IP is protected. So patents allow you to protect your IP, and it helps you secure investment. Obviously, patents would be used for warning off competitors, and so they can be used from a defensive perspective. But I would say often for startups and small to medium-sized businesses is that patents can be used for marketing kudos, in that if you are competing against another startup in the same area and you want to do business with a larger company, if you have a patent and your competition doesn't, it allows you to give the company that you're going to do business with a bit of confidence that you're the better choice to choose rather than the company that doesn't have IP. So these are just some basic criteria. you know, today, this person, they have patents, he's happy, he's got his mask on, he's running up, the value of his company is increasing. And finally, I know I only have 10 minutes and I'm on to my last minute. There are different types of patents. There's a patent filing strategy for, you know, every company and every budget. There's a patent filing strategy from a small startup to a medium-sized company to a multinational. They all don't have to be the same. These are different types of patents, that applications that we can discuss in further detail. Yeah, so what the main message is there should be a patent strategy no matter what your size, no matter what budget you have, and we FR Kelly can be there to assist you to take those first steps. So my 10 minutes on patents is up.
That's great, Paul. Thanks a million. If you could unshare your screen there, that'd be great. That was really interesting, and I'm looking forward to going and reading those slides again and digesting them again on the basis of what we've learned today. So next up is talking about trademarks. Today is Sumi Nadaraja, partner in FR Kelly, who counsels their foreign and domestic clients in the selection, clearance, prosecution and monitoring of Irish, UK and EU trademarks. So Sumi, if you could share your screen and give us your 10 minutes whistle-stop tour of trademarks, that'd be great. Thank you.
Thank you. Thanks, Rosemary. Right. So my talk today is on trademarks and basically branding and the importance of branding to your business. So a trademark is essentially the legal term for a brand or your brand name, and it's very often the most valuable asset of any business. So for instance, we are all familiar with trademarks, you know, and they're coming to us from all directions. So people will be familiar, obviously, with the Coca-Colas and Microsofts of this world, or to bring it more local, we have our own local well-known brands, which are international brands today, such as Guinness, we have Ryanair, we have Pennies, we have Jamison's, and these trademarks, these brands are worth billions today. And taking up from what Paul said earlier, they all started somewhere, and they all started with one single mark, one single idea, once upon a time. And you know, again, they're huge, valuable assets in today's world. So there are a number of reasons, or a number of reasons why trademarks can be valuable to your business. And the most obvious reason is obviously a registered trademark gives you exclusive rights in the name of your either business or the brand that you're trying to market. This essentially means that it allows you to prevent a competitor from any unauthorized user of using the same name, and it actually gives you legal recourse against it, which is invaluable for any business, really. In addition, obviously, a registered trademark will give you the ability to prevent counterfeit products. So basically, if you have a trademark registration, all you need to do is go and record that with the customs authority, and the customs will do the rest of the work. So it means that if you have products which you are concerned might be copied in other countries and be coming into this jurisdiction, you know, your registered trademark is really the very first step in which you can, you know, to assist you in preventing that. Trademarks can appreciate in value over time as well, you know, and so you'll find, and I'm sure most of you watch Dragon's Den, so you will see that if a large corporation wishes to acquire your business, one of the first questions they'll ask you is, show me your trademark registrations. So these are really very important reasons for which your trademark registrations are very important to your business. And trademarks are a property right. So essentially, what it does is that it allows you, just like real property, to it can be sold, it can be leased, it can be it can be used as a security interest against which you can borrow money, get a loan, raise a loan from financial institutions. And most importantly, trademarks are the only form of intellectual property that can exist forever, basically in perpetuity. And that is because a registered trademark just needs to be renewed every 10 years in this country, in Europe as well. And it can literally, outlive the current owners of the company. So, for instance, you'll see many trademarks. Many of the world's most valuable brands have existed for more than 100 years at this stage. For instance, the Guinness apparently registered their harp in 1876, and that is why you will see the Irish Free State, which came up in 1922, had to register their harp in the opposite direction. So you can see that's the power of a trademark, a registered trademark, and that's what you want your brand to be. So I'm going to turn very quickly to the key areas in protecting your brand, or your trademarks. Right. So let's start off with brand selection. So to select a brand, firstly, before you decide to name your company, it would make commercial sense to actually decide on what type of brand you're looking for. So trademarks can consist of either invented words or names and letters or numbers, logos, slogans, etc. And you can see that I've actually provided some examples of both international and Irish brands. Tan Organic is an Irish brand which is now gone global. That was one of the Dragon's Den's brands, in fact. But there are also other brands here. You can see like Air Lingus, Water Wipes. These are all different types of brands, and these are all the different type of ways in which you can protect your brand. For example, an example of names and letters would be U2. That's like a very famous brand as well. So it's very important to firstly select your brand, right, and decide what and decide how you wish to be represented to the world. One of the most important things, and if I was to only give you one tip about brand selection, is that the most valuable trademarks are the ones which are not descriptive. So try not to choose brands which are going to describe your business, right? And the coined terms, the ones which are arbitrary, fanciful, those are the names like Kodak, Sony. Those are the names that are the most registrable. So if you're trying to register that as a trademark, those will go through the registration process quite easily and without great difficulty. If your trademark is too descriptive, you'll probably find it more difficult not only to register it, but also to keep defending it and protecting it throughout the world. So once you've decided on the type of brand, the brand name that you have, the first and most important thing for you to do is to clear the brand, to make sure that you're not stepping on anybody else's toes. So for instance, a lot of brand owners, even if they don't decide to come to IP professionals, the very first thing they should do is do internet searches, see if your competitors actually are using something similar. And if they are, then you should steer clear. Very frankly, what I would suggest, this is the best investment for any entrepreneur, is to actually get an IP professional to conduct a brand search for you, a trademark search for you, because basically trademark searches they don't only search identical, provide advice on identical marks. Don't forget your trademark rights actually also extend to similar trademarks. So it is very important for you to be absolutely certain that you're not in danger of being sued for copying or being close to someone else's brand, which you might or might not be aware of, right? And if you, and it's very quick. If you got an IP professional to do it, it would take about a week, especially for Ireland or the UK. So this is a very quick and easy way of trying to prevent difficulties arising at a later date. So I've put up some slides here, really just to share with you some ideas of what searching can throw up. So for instance, the very first line there, you'll see Coffee Rocks versus Starbucks coffee. Now, if you were Coffee Rocks, you would probably assume that this had absolutely nothing to do with Starbucks. Yet, Starbucks successfully managed to prevent the registration of that trademark. Simply because this actually went up to the European courts, and the courts decided that there were too many similarities, similarity in color, similarity in the logo, and obviously Starbucks has a huge reputation. So one of the big tips that you should be taking away from this conversation is you might be inspired by some of these big names, but try your best not to actually copy it to the extent that it's actually recognizable, because it could actually cause huge difficulties down the line. A few other examples: the Wild Atlantic Way. This was a trademark which was filed by an Irish individual. They were not aware that Bob Folger had this Wild Atlantic Way trademark already registered as a European trademark, and because the Irish Patent Office decided that the Irish Tourism Board's rights predated the Irish applicant, but also the most distinctive part of that trademark were the words Wild Atlantic Way. So that he was actually stopped from actually registering that mark. Another example, Skyworth versus Sky. And again, Sky, B Sky B or Sky International, they are quite known within the industry for being very litigious. And this is another thing that you might want to remember. Some trademark owners are extremely litigious, and they keep a very strict eye on the registers across the world. So they might take steps to stop you. And if you haven't done your due diligence, you might not know that they're going to come after you, and it's going to cost a lot of money to actually change your brand once you've already spent a lot of resource towards marketing, etc. So these are little pointers to take on board. Interestingly, I just threw the last one in because I wanted to show you how why you might actually need an expert looking at this rather than deciding yourself what similarity is. The handy pack versus handy bag marks, interestingly, were found to be dissimilar, and that's because the words handy, both those trademarks actually, the wording themselves are very descriptive, so they were just not taken to be a very distinctive part of those marks. So in short, if you want, once you've decided on your brand, it's very important to get it cleared. It's best to get it cleared by an IP professional. This would be my view on this, my advice. So moving very quickly on to brand registration. Registration is pretty straightforward. It's very, very important, actually, as I've enumerated the number of reasons why. I do think that it can sometimes be daunting. There's no need, if you're trading in more than one country, there's no need to register your trademark across the world, in one big go, simply because it's going to cost a lot of money. But there are strategies around this. Again, IP professionals should actually be able to tell you and be able to advise you. The application process is pretty straightforward, but it's not immediate. So if the average time from start to finish of a trademark registration is really between about 6 to 9 months. 6 to 9 months in Ireland, maybe 9 to 12 months at the EU. There are different type of registration processes, and basically brand registration works on a jurisdictional basis. So it means that your protection is usually limited to one country. In Europe, we're extremely lucky because we have a European Union trademark, which provides us with protection in all the member states. Of course, with Brexit coming up, this will no longer apply to the UK. So the UK will have to be applied for separately, and your registration will have to be separate in that country if you haven't already sought registration there. Once your mark is registered, it lasts for 10 years. And as I said, renewable indefinitely. Once your mark is registered, these are the three main areas in which I would really encourage you to pay attention to. You should actually monitor what your competitors are doing and make sure that they're not stepping on your toes. So there are different ways of monitoring. The most basic way, obviously, is for you to do internet searches. But then there's also a trademark watch service, and your IP professional can help you do that. Also, the minute you find a competitor infringing on your rights, it's very important to try and enforce your rights. Again, you'd have to make a call as to how important it is, what level of infringement is going on, and your IP advisor would be able to issue a cease and desist letter as the very first step. So you don't always have to go straight to the courts, although it might sometimes end there. But it is very important to enforce your rights, because that is the whole purpose of owning them. And it is also important to continually review your the use of your brand. So sometimes I find that brands, they might start off with one particular product, but then they might take a slight different turn, and you might actually find that they're great, a different number of products all falling under your brand, but your brand registration is only covers a limited specification. In which case, it is important to constantly review your trademark portfolio and to ensure that this is it adequately covers what you currently own. I've thrown in the TM and the R symbol at the very bottom, and that's because the R symbol is it depicts a registered trademark, so you cannot use that unless you actually own trademark registration, a registered trademark. I have thrown together a very quick number of slides on the perils and pitfalls. Most of these Paul has already talked about, and I fear I might be actually coming up to time. I tend to ramble a bit. So I am going to just go, I only want to share with you one last slide really, and this is the most significant one. In 2019, a report was issued by the EPO, that's the European Patent Office, and the EU IPO, that's the Trademark and Design Registry of Europe. And basically, they did a huge study over a period of time, just discussing and just on the the practicalities of IP rights in relation to SMEs, right? And what they found, which I think will be very significant to this audience particularly, is that SMEs who owned any type of IP, and particularly registered trademarks, and again, you can see the stats up here, there was a significant likelihood of them being able to see a period of growth. And why was this? Very quickly, the reason behind it is because once you take the commercial step of protecting your trade, or your, not just your trademark, but your intellectual property, but once you've taken that step of doing so, it really just inspires confidence, not only in consumers, also in potential investors, and because it shows that you have a mindset that is actually geared towards growth, right? And of course, in this audience, particularly with you being such innovators, this is particularly important to bear in mind. So your intellectual property is really, it really is also a bit of a business statement. It's a statement of your commercial acumen, and it's definitely something that we would encourage you to take on very seriously. I think I've come up to time here, so I'm going to end off here, and thank you very much for listening to me.
Thank you, Sumi. That was fascinating, and really enjoyed that, and would love more than 10 minutes with you. So we're going to have to do all this again another day when we have more time. Aidan, I see the questions are coming in unbelievably, like there's loads of questions. I know, David, you've been answering some of them there, but I think there's a few more there that we could get the guys to answer live. They might be of benefit to everybody. Aidan, do you have a few?
Yeah, I think there's been a few questions around approximate costs. So maybe if Paul and Sumi could give some indication. I know it's difficult, I suppose, but, and I know Paul answered to one individual there, but maybe just give a rough indication of overall potential costs for a patent, first of all, and then Sumi maybe on the trademarking side as well.
Yeah. So the most cost would involve actually the preparation of the patent document. So that is in getting a patent attorney to go through your invention and put it in legal terms so that it's best protected. But on average, we would say the average cost of filing a UK or Irish application is probably around €4,500, depending on the technology. Obviously, if it's basic, it's cheaper, and if it's like a very, very high tech It's much more, it's complicated. It depends really on how much work is involved. That's attorney time. The official fees are quite standard, you know, they're not that expensive, but it's actually preparing the documents is where the time, where the costs come in. So the average cost, I would say, to get a UK patent application on file is probably around €4,500, and it goes up if it's more technical. A US application, someone asked me, the average cost there to get it on file is probably, I would say, €8,500. The cost again preparing is much the same. You could say the ballpark is probably around 4,500. But then there's further costs. There's the US official fees and US attorney fees that add that bit extra. But then there's prosecution costs after filing. So there isn't a whole lot of prosecution costs in a UK application. It's quite straightforward. It's not that expensive. You probably get a UK application after filing, probably for another, you know, €1,000 or €2,000. Okay. But in the US, there is a bit more work involved and more costs involved. So an average, a US application from filing, that's the total preparation to grant, I would say, this is a ballpark figure that I reviewed from multiple different firms. They would say somewhere between €12,000 to $12,000 to $15,000 over a 36-month period. Obviously, it can vary, but that's the ballpark.
Brilliant. Thanks, Paul. And Sumi, on the trademarking side, ballpark figures?
Yeah. So in terms of trademarks, similar to what Paul was saying, trademark fees really depend on the exact products or services that you're claiming under the trademark. So if there's more than one product on offer or more than one service on offer, the fees increase accordingly, right? But to give you an idea of ballpark figures, again, the official fees, particularly for an Irish trademark, are fairly standard, and I think they range around about the €200 mark. But if you're getting a trademark attorney involved, because the expertise really comes in with the drafting of the trademark specification, it can go up to about €800, we'll say, for a trademark, so very much less than a patent, for instance. The European Union trademark is, which I mentioned earlier, is a much broader, it gives you much broader protection. It covers you in 27, well, not currently 28, but soon to be 27 jurisdictions of the EU. And that'll be in or around the €2,000 kind of range. And again, if it all really depends on the number of classes, the number of classes that you're looking to protect your mark in, and that, you know, the cost goes up depending on what exactly you're looking to protect.
Okay. All right. Thank you very much, Sumi. Cheers.
Great. So we'll move on to David, who is a partner also in FR.
Sorry, Rosemary, we will get to the other questions at the end as well. Yeah.
Yeah, sorry. David's up next, David Brophy, a partner in FR Kelly also, like the other two folks, and works with clients to understand how design rights and copyright can be used strategically to protect creative efforts. So, David, are you able to share your screen there? David has beautiful photos and pictures in the back.
Sorry, Rosemary, you're frozen me there for a second.
Okay.
So apologies, you were waiting on me to jump in. Okay, so hopefully you're seeing the slideshow. Thanks very much. I, as I said, I'm a partner. I work in patents. I also do a lot of work in design and copyright. So I'm going to try and round out, again, in 10 minutes or so, I'm going to try and round out different kinds of IP with some of the ones that get less attention. And I'm going to start by talking about designs. Now, designs are known as the Cinderella of IP, which is why we have the glass slipper there, which means that the two systems of patents and trademarks, they get to go to the ball, they get all the attention. And for many years, designs have been, sort of left in the corner, not getting as much attention. They do serve a purpose, but they haven't been used very widely. But in the last 10 years, there's a lot more attention, and there's been some high-profile cases where companies have used design rights rather than patents or trademarks to try to get their competitors to give them some free space. The thing about design is they protect how something looks, the visual appearance of a product. And the products traditionally that design's protected were physical, something you could drop on your foot. But as you can see with the word logo, they nowadays are also protect digital lines. And I will come to some of those to give you an idea of how the design system has changed over the few years to protect, things that are not physical. In Europe, when we talk about design rights, there's two different kinds. We have registered rights and unregistered rights, and they both have different properties. Unregistered ones, obviously, you don't need to do anything. They're automatic rights that come into force. They last for just 3 years, so they're very suitable for products like fashion, as you can see with this Karen Millen shirt, which was copied by Dunnes Stores, where they used their unregistered rights to take the Dunnes Stores shirt off the market. One of the difficulties with unregistered rights like this is that you need to prove that the person copied you, and that can be quite difficult. They did manage, in the Karen Millen case, they did manage to prove that Dunnes Stores had actually gone in, bought some of the Karen Millen shirts and made copies of them. That all came out in court, but you may not always be able to prove that. So both because it's short-lived and you have to prove copying, registered rights tend to be stronger and better. They will last for up to 25 years and you don't need to prove copying. You just need to prove that the other person's product looks the same as your registration. And if they do, it's infringed, it's cut and dried. So with designs, another feature of the system is you don't have to protect the whole product. You can see a teapot here, and you can see that on the right we have got just part of the teapot without the lid. You can also protect just the rim of the teapot with the handle, and at its most basic, there's a registration just for the handle on its own. And what that means is that that last registration would stop any using that shape of handle, whether it was on a teapot or a jug or even in some bizarre sort of car door handle. Protection for that. So you can use this system to kind of slice and dice the design of your product and pick out the parts that are most interesting or most likely to be copied or most valuable, and get registrations for those individual parts. What does a design look like? A patent, if you've ever read it, is a long written document with some drawings at the end. A design registration is really just drawings. So you get drawings or even photos of your product, showing it from all sides, and you bang that into the patent office, and they will usually very quickly and without too much objection give you a registration for that product. So anybody who produces something similar after that will be infringing. Some other examples of it here, you can see it used in the car industry and the electronics industry. Something interesting about these two is that we have on the wheels of the car, you can see there, maybe you can see in broken lines, and the back of the iPhone is shown with broken lines also. What that means is it's shorthand for saying that the design isn't limited by those features. So for the iPhone, for instance, anybody who produces a phone with this curved bezel going around the edge of the front of the screen and the home button in that place, infringe. It doesn't matter how big the screen is or what the back of the phone looks like. So again, they've sliced and diced the iPhone design, and they've got loads of different registrations to try and protect all the aspects of it. Now we move into digital design. So these are not physical products. And again, as Apple. Apple have individual registrations for each of these different parts of their operating system. So what they're effectively doing is they're saying to Samsung and Google and everybody else in the industry, you can have a slide to unlock button, but you can't make it look like my slide to unlock button. You can have a microphone pop-up icon, but you've got to design it to look differently. And when they do that with hundreds of parts of their operating system, effectively, they make the rest of the industry design around every part of their operating system. And in that, they effectively protect the look and feel of their whole operating system. And that's not just for large companies like Apple. You can do that with a website, you can do that with an app, you can do that with anything that you release. You can pick out individual parts and set a whole load of traps on your product design to stop people from imitating. I showed you at the start this word icon, which obviously people will be very familiar with. When this was registered, it was actually registered as shown on the right with a line drawing. Two interesting things here. First of all, they took out the W, so they show that in broken lines. So it protects, that icon is protected without the W or with any other letter or any other symbol in that place. And the second one is they took out all of the color. So they protected this. And if somebody comes up with a similar icon in red or in black or in any color, they will still infringe as long as it's the same shape. So if you get good advice when you're filing for design registrations, you can broaden out the scope you're protecting and try to catch more people or stop people from imitating different parts. And then the final example I'll show you is moving designs. So this is effectively like a flip book where I've put together the 11 different drawings in a design registration, and it covers a moving icon from Nokia as a phone shuts down. And this is now being used really widely for animated icons, for different parts of graphical user interfaces, for anything that moves, you can protect it in a way. So even though it's a paper-based system at its heart, people have found ways to adapt it to the digital age. So why do you register your designs? Obviously, you can register lots of different parts, but why would you go about doing it? Well, it's very similar to patents, as Paul was talking about. You want to protect against copying in the first place, and that's their primary use. You also deter competitors, deter people who you may not know whether they ever thought about copying, but when they see on your product or they see on your website, they see registered design or in the US design patent, they may just decide to find an easier way and to find a different way of designing their own product. They'll steer clear of yours. It's a way of getting registered IP onto your books. So if you want to show your investors and to show your competitors and show the public at large that you have IP, it may be that what you have doesn't qualify for patent protection because it's not technical or for any of the reasons that Paul has said, but you may still be able to get design registration. And the two of them work in parallel. So you can have both a patent and a design. The iPhone has hundreds of patents and hundreds of designs. You can have them in parallel, or you can get one without the other. So sometimes when you can't get a patent, a design registration is a good alternative. And finally, it's quick and inexpensive in comparison. There's been questions about the costs. I can tell you for Europe, a design register, if you budgeted €1,000, you would have the whole thing from start to finish. And then they allow you to add on additional lines, just additional variations for a lot less. So for a couple of €100 extra, you can add on a second and a third and a fourth. You know, it doesn't cost a huge amount of money, and they tend to register it within the space of, you know, weeks, months, rather than years. So it's a very quick way of getting some IP on your books. Now I'm going to move on to copyright. This is a very broad area, so I'm only going to touch on the parts that I think matter to most businesses. Copyright covers all sorts of things. Obviously, if you're in one of these industries, if you're producing films, copyright is going to be, you know, the key right that protects everything you own. And most companies won't have any interest in most of these areas, but every company is going to have some copyright. First category that's really important is literary works, and it's not just published books. Companies will produce written materials that are original. We have an inventor's guidebook and a whole load of other guides that all have copyright. Software, the code of software is regarded as being a literary work. It's kind of a legal fiction that it falls under the category. But all of software code is protected by copyright. And then your website will have original written work, and all that will be protected by copyright. The next category that's really important for every business is artistic works, whether it's drawings or photos, whether it's logos, or again, your website. You will have some artwork in almost every case that you own in your business, or you should own in your business, and that you want to make sure is protected properly. And the last category, I think, applicable to a lot of businesses, is databases. So you can see here there's a list of very unromantic components and valves and connectors. There's no copyright in the name of these valves. There is no copyright in the serial number they've given to them. There may be some in the photographs, but the collection of all of this information into an organized database, copyright and get other IP rights. So if you have put an investment, time and money into getting together materials, organized systematically, you will get protection to stop other people from going in and taking material from your database, reuse material. So that's another one that you know, isn't always to the forefront of people's mind, but it's very valuable information and a valuable is the collection of data that you have that other people don't have. Avoid copyright infringement it's one of the key risks for any business. Particularly, we see a lot where people will use on their website, they will use in their brochures, in their presentation, will find photographs somewhere on the internet, and they will reuse it, and they'll be infringing copyright in almost every case, unless they've cleared the rights in advance. It's easy to avoid copyright infringement because you only infringe copyright if you actually copy someone else's work. If you create your own work, or if you get someone to create it for you, then you can't infringe someone else's copyright. So creating original work gets you around every kind of copyright. It might be easier said than done, but you can usually get someone to create something for you. And when they do, you've got to be very sure that you own the rights. So if someone creates something for you and they're one of your employees, the law in Ireland is normally that you own it if they created it in the course of their duties. But you also want to get a contract of employment. So you should check the contracts of employment that you do own IP rights for any employees who are likely to be creating anything. A much bigger pitfall is when you get someone outside your business who isn't formally employed by you to create something for you. And this happens all the time, and we see it very often where someone has created something and you've paid them for it, but they've never actually assigned over any IP rights. You must get an assignment in writing if you're going to own the copyright. And if you don't, they own copyright. And it's a misconception that people have, and it can cause you, it can come back to bite you when you try to get an investor into the business, or you try to sell the business and somebody starts doing due diligence and they say, well, do you own these key assets of your business? And you can't put your hands on a written assignment. It's something you can do retroactively. You can go back and recapture and look at what you have and go back to the people who created for you and say, look, lawyers are making me do it, but I need you just to formally sign over these documents and get your house in order that way. And then lastly, how do you secure copyright? There's no costs, there's no process, it's automatic. So copyright comes to be automatically for you as soon as you put something down on paper or record it on the computer. So copyright's an automatic right, and it's very easy in the way. Where it's difficult is that people don't keep a record of when they created it or where they recorded it. So you've got to keep good records with copyright. So you can put your hand on it again and you can say, well, you know, on this date, I already had it. You also want to let the world know that you have copyright so that they can't claim they didn't know who to ask permission for or who to pay a license fee to. So you see the copyright note that you will see where make sure you put that on any original work that you release. And then finally, and to reiterate, get an assignment or a license for everything that you're using in your business. Make sure that you're not using stuff that's unlicensed, or when you get stuff created for you, that you make sure to sign a piece of paper or send you an email saying you own this, and make sure that you have your house in order. And that's the end of my stop tour of designs and copyright. So thank you.
Thanks, David. That was fantastic. There's buckets of questions which we're trying to answer some of them online, but because we're going to eventually run out of time, but hopefully we'll get to do a few live. I'm going to ask Joe Doyle, the IP manager and IP specialist from Enterprise Ireland, to share his screen now and give us a little bit of a roundup of what supports there are from Enterprise Ireland and their perspective on their IP strategy. Thanks a million, and please forgive the copywriting typo on the ad, which shocking. I have tried to fix it in the subsequent social media and everything. Joe,
I nearly put in a couple of slides, Rosemary, where I gave you best practices to write a catchy punchline, but I thought it was outside my area of expertise.
Fair enough. Joe, we'll hand over to you.
Okay, hello everyone, and thanks for the invitation, Rosemary and Aidan. Can you all hear me okay? Or Rosemary at least?
Yes, we can, yeah, perfectly.
Good. Okay, and can you see my screen properly?
Yep,
in the
perfect.
display mode. Okay, good. Okay, good morning everybody. I realize we're running short on time here now, so I'll try to be super quick. I'm not going to talk about IP. You'll be happy to hear. There are experts that have done that for us. What I want to talk about is very briefly the role that IP plays in fast-growing companies and what Enterprise Ireland is trying to do to support that. So I've got to reference a few reports, but you'll be happy to hear that I'm not going to get into them in any detail because I've put embedded links into the slides. So if anybody wants to read some more, please be my guest. But I work for Enterprise Ireland, and our client base are largely startups and SMEs. So and we all know this data, SMEs are a very important part of the economy, as example here in total employment and value add. However, when it comes to IP and SMEs, unfortunately, SMEs are about 4 times less likely to own IP than larger companies. However, if you look at the bar chart on the side there, the SMEs that do own IP are significantly more likely to exhibit scalability in different metrics. But if you look at revenue per employee, for example, an SME with IP is about 30% more, or will have 30% more revenue per employee compared to those without, on average. This is across a huge section, or a huge sample of companies, of course. So I guess the point is that SMEs are not a generic category. And so there are some companies that tend to exhibit high growth potential, and that those companies contribute disproportionately to the economy, essentially. So it's very important that we can identify these companies and support them appropriately. And they tend to have certain characteristics, i.e. they're innovative in risk-taking, they're exporting, they tend to have stretched resources largely due to their high growth, and they're based on human capital, R&D, and intangible assets like IP. So it's important that we know how to identify those companies. And one of the indicators of high growth potential was highlighted in this report from the European Patent Office and EU IPO last year. And basically what this showed was that companies that protect their IP early on in their growth tend to exhibit phases of high growth later in their life cycle. I'm sorry, you probably can hear that the postman has just arrived here. My dog is barking downstairs. Apologies for that. So basically what this says, and I'm not going to go into the detail into the report in much detail, but what it says is that the companies are about 20% more likely to experience high growth in the future if they protect their IP early on. So what that means is that we need to support companies to protect their IP earlier than they do at the moment, but also companies that do protect their IP and that develop diversified IP strategies are more likely to exhibit high growth in the future. So that's an important point for investors and for public policy, but for companies themselves. So to try to emphasize the point, I'm going to give 2 very brief examples of where IP challenges can arise with companies and why companies need an IP strategy. So Crocs, the Marmite of footwear, there's a link to the story there. I won't get into it in great detail, but David was talking about registered designs, and this is an example of a European registered community design where Crocs enjoyed this protection for a few years, and one of their competitors, who was one of many companies producing knockoffs of Crocs, decided to invalidate their registered design by pointing out that Crocs had displayed their design at a trade show, I think it was a boat show in fact, in Florida in about 10 years earlier or something like that, and that they didn't protect the design within the time limit that they were allowed after disclosing their design. So they actually lost that registered design in Europe because they didn't, when they were an early stage company, they didn't put the protection in place at that point. Another example, and I guess one point is that I've intentionally not used patent examples here because I find that when people talk about intellectual property, the conversation gets straight into patents. And while I'm all for patents, there's a much wider variety of intellectual property, and some forms of intellectual property are much more common than others. Copyright, as David mentioned, is one of those. So I don't know if anyone is familiar with this photograph, but this is the Selfie Monkey. And this is kind of a funny story, but it's a real story where the photographer set up cameras in the jungle to take pictures of these monkeys in Indonesia. He left the cameras for a while with the settings on, and this monkey came along and pressed the shutter button. And he got this great photograph. So to cut a very long story short, there was a debate about whether or not, or some people perceived that the because the monkey created the photograph that he owned the copyright. So an animal rights group in the US brought the photographer to court for stealing the monkey's copyright. They didn't win, but it cost him a fortune to retain his copyright. And so I guess it goes back to the point that David made earlier, that that the creator of the copyright is essentially the owner. That's the starting point. And so it's very important to make sure that you own the copyright that you claim to have. So what Enterprise Ireland does is to help companies who have this intellectual property, is that we have a new grant scheme to help you bring in the sort of expertise that we've heard from the three speakers that came before me, to help you to develop an IP strategy that's appropriate to your business. So we're not prescriptive about what that is. We ask you as the company to identify what your IP challenges are, and we make a grant available to you if you meet the eligibility criteria on the left-hand side of the screen there, to bring in that external expertise, but also to help to develop your in-house capability so that you're taking more control of your IP strategy. I hope all the information that you need for that about that grant scheme is on the screen for you. There are links, obviously, and I think, Rosemary, you'll be sending copies of the slides. Yeah. So, and my contact details are at the bottom. So essentially the purpose of that scheme is to get companies to start to address their IP as early as possible so that they're retaining the scalability that's inherent in their innovation for the future. And I'd be delighted to hear from anybody that has any query about that. So I think that's all I have to say.
That's great, Joe. And I think you mentioned also an IP and Brexit webinar that you guys are running.
Yes.
And we'll forward that information out when you send it to us. I think it was in answer to a question that was up in the Q&A box.
Yes, that's right, Chad. That's on the 11th of November. I don't have a link to send yet. I may have by the end of today, but I will send it to you, Rosemary, and if you want to send it to everybody on the
that'd be brilliant.
List here, yeah.
Brilliant. Great. Well, listen, because we're kind of running out of time a little bit, we don't have time for questions. We had a huge amount of questions that were answered by the speakers and the panelists. And we'll forward on any questions that people have if you want to get in touch with us. Now, not forgetting, Joe has given his contact details. We'll be sending out the deck, so that information will be there if you want to get in touch with Joe, particularly about that new scheme that EI are launching in the next little while. And the guys at FR Kelly want to remind you that they have offered one-to-ones to anybody who's on this webinar. So if you have very specific questions or your question didn't get specifically answered in the detail that you'd like because it's of a sensitive nature, etc., you can book a one-to-one. Obviously, I'm assuming guys done virtually at the moment, which is handy because you can be anywhere in the country and have a chat with these guys without making huge amount of effort. So we'll just briefly want to tell you about our new next webinar, which is in 2 weeks. I know we have a number of social enterprises and social entrepreneurs following us at the moment because we're involved in a European project called Sunsay. So we're holding a webinar all about social enterprises, creating a supportive environment for social entrepreneurs. And that's on the 5th of November. You'll find it on Eventbrite if you look for Sunsay webinar, or you can get in touch with us and we'll book you on. So that's going to be a great one. And we're also launching a search for the Southeast's top scale-ups and startups. So we're running a pitching competition celebrating our 25th birthday, and we want to get innovative, ambitious startups to pitch for us at our birthday party, virtual birthday party, on the 26th of November. So the application forms for that are on our website at the moment. There's some really cool prizes, and there's an opportunity to network virtually with some of our top clients at our Celebrating Success event on the 26th of November. So just want to remind you all about those two next things. Huge thanks to everybody for their efforts and time today, particularly to Philip Coyle and Brian Claffey at FR Kelly for organising all of this, and for connecting in with us over the last few months and building that relationship. We're delighted now that we have connections with FR Kelly, and it's going to be really beneficial to our clients to avail of this opportunity. So huge thanks to Paul, Sumi and David for their time today and the preparation that went into it. And I think there was 30 questions asked and answered over there. So that's fantastic participation from you guys, the attendees. Big thanks to Joe Doyle of Enterprise Ireland for giving his time today as well, and explaining to us the opportunities that are there for support from Enterprise Ireland for their clients. And thanks to everybody in South East BIC for your support and promotion at the event. So thank you all, and we will hopefully see you again in the next little while for our next webinar. Cheers.